Article 203 of the Indian Constitution delineates the procedure in the state legislature regarding the estimates of expenditure. Expenditure charged upon the Consolidated Fund. Expenditure that is automatically provided for and charged upon the Consolidated Fund of a state, as specified in Article 202(3), shall not be subjected to the vote of the Legislative Assembly. However, this clause does not prohibit discussion in the legislature about these estimates. This means that while the Legislative Assembly does not have the power to modify or reject expenditures charged upon the Consolidated Fund, it can still deliberate on these estimates and engage in discussions regarding them. Other expenditure. Estimates of expenditure that are not charged upon the Consolidated Fund, as outlined in Article 202(2)(b), are submitted in the form of demands for grants to the Legislative Assembly. The Legislative Assembly is empowered to assent to any demand for grant, refuse to assent to any demand for grant, assent to any demand for grant subject to a reduction in the specified amount. This grants the Legislative Assembly the authority to approve, reject, or modify proposed expenditures beyond those already charged upon the Consolidated Fund. Recommendation of the Governor. Article 203(3) mandates that no demand for a grant can be made except on the recommendation of the Governor. This underscores the role of the Governor in initiating the budgetary process and ensures executive involvement in financial appropriations. In essence, Article 203 outlines the framework within which the state legislature exercises its authority over budgetary matters, distinguishing between expenditures automatically provided for and those subject to legislative approval. It also highlights the Governor's role in initiating the budgetary process by making recommendations regarding financial appropriations.
The Constitution of India. Part 6. The States. Chapter 3. The State Legislature. Procedure in Financial Matters. Article 203. Procedure in Legislature with respect to estimates. 1. So much of the estimates as relates to expenditure charged upon the Consolidated Fund of a state shall not be submitted to the vote of the Legislative Assembly, but nothing in this clause shall be construed as preventing the discussion in the legislature of any of those estimates. 2. So much of the said estimates as relates to other expenditure shall be submitted in the form of demands for grants to the Legislative Assembly, and the Legislative Assembly shall have power to assent, or to refuse to assent, to any demand, or to assent to any demand subject to a reduction of the amount specified therein. 3. No demand for a grant shall be made except on the recommendation of the Governor.